Welcome to literary and jury charge practice. Let's start out with this narrative answer. Ready? Here we go. I understand the patient had been brought to the hospital by ambulance after she was injured. I examined her there at the hospital on June 12. There was a discoloration around the area of injury that extended down the arm to the tips of the fingers. My diagnosis was that of a compound fracture of the right ulna. The treatment was routine. The surgeon performed an open reduction and the patient was returned to the ward on June 14. On that date, I examined the patient and continued her treatment. I followed her condition until June 17, at which time she was discharged from the hospital with orders to return to the outpatient department in 1 week for examination and further treatment. I have checked with her family physician, and I can say with some degree of certainty that the patient should recover full use of the arm. Let's try one more short narrative answer. And it looks like this one is regarding an autopsy. Ready? Here we go. The autopsy confirmed that there were fractures of the skull as described by the surgeon who operated on the patient when he was first brought to the hospital. There was subdural blood in the cranial cavity. A normal pattern of convolutions was described. The cerebral hemispheres were symmetrical. There was no discoloration or hemorrhage of the white matter. However, the course of the bullet left a discolored path. The ventricular system was without any distortion. The pons medulla and cerebellum were unremarkable. The vessels at the base of the brain have a normal pattern. There is no aneurysm present. One tattoo was present over the dorsum of the right hand. There was a marked pallor of the skin. Examination of the eyes revealed the pupils to be equal. The abdomen was flat. There was no edema, and there was no joint deformities present. There was no fracture or injury of the hyoid bone or laryngeal cartilage. Rigor mortis was absent. Lividity was found over the posterior surfaces. Rib fractures were not present. There was no surgical scars of the chest. There were no resuscitative puncture marks on both arms and the left hand. Hopefully you're feeling warmed up now. And we will work on some jury charge material. And this is our jury charge called Power of the Court of Appeals. Ready? Here we go. In his answer to the show cause orders issued by the Court of Appeals, the petitioner amplified the reasons for the references, stating that the cases were very complicated and complex, that they would take considerable time to try, and that his calendar was congested, declaring that the references amounted to a refusal on his part as a judge to try the cases in due course. The Court of Appeals concluded that in view of the extraordinary nature of these causes, the references must be vacated if we find that the orders were beyond the court's power under the pertinent rule, and if, being so found, the writs were issued. It is not disputed that the same principles and considerations as to the propriety of the issuance of the writs apply equally to the cases. It appears from the docket entries that the petitioner was well informed as to the nature of antitrust litigation, the pleadings of the parties, and the gist of the plaintiff's claims. He was well aware of the theory of the defense and much of the proof which necessarily was outlined in various requests for discovery, admissions, interrogations, and depositions. He heard arguments on motions to dismiss, to compel testimony on depositions, and for summary judgment. In fact, petitioner's knowledge of the cases at the time of the references, together with his long experience in the antitrust field, points to the conclusion that he could dispose of the litigation with greater dispatch and less effort than anyone else. Nevertheless, he referred both suits to a master on the general issue. Furthermore, neither the existence of the alleged conspiracy nor the question of liability vel non had been determined in either case. These issues, as well as the damages, if any, and the question concerning the issuance of an injunction were likewise included in the references. Under all of the circumstances, we believe the Court of Appeals was justified in finding the orders of reference were an abuse of the petitioner's power under Rule 53. They amounted to little less than an abdication of the judicial function, depriving the parties of a trial before the court of the basic issues involved in the litigation. The record does not show to what extent references are made by the full bench of the district court. However, it does reveal that petitioner has referred 11 cases to masters in the past 6 years. Even a little cloud may bring a flood's downpour if we approve the practice here indulged, particularly in the face of presently congested dockets, increased filings, and more extended trials. We'll take a little break from this one. And let's get back to our literary material on the coming eclipse. We had started an article called Hello Darkness, a total eclipse of the sun comes to the U.S. in August. Ready? Here we go. The Umbra will come ashore on the Oregon coast west of Salem at 10:15 a.m. Pacific Daylight Time. Here, those sitting at the center line of the shadow will experience 1 minute 59 seconds of totality. The length of the eclipse gets longer as the 68-mile-wide Umbra speeds across the heartland, with the greatest duration occurring in southern Illinois, where Espinac says totality will last 2 minutes 40 seconds. Viewers should also consider weather statistics. Sighting odds decrease for the eastern U.S., according to Jay Anderson, a retired meteorologist at Environment Canada with nearly 40 years' experience in studying eclipse weather. The farther east you go, the cloudier it gets, says Anderson. Following several eclipses with less than ideal circumstances, the relative accessibility and favorable weather forecasts for August have pushed this year's event to the top of Eclipse Chasers' list. It's no accident that the Astronomical League, an organization of more than 240 amateur astronomy clubs, is holding its annual conference in Casper, Wyoming, days before the eclipse. With hotel rooms and campsites at a premium, many of us may find ourselves reconnecting with long-lost relatives from Idaho or Nebraska, among the states with the best viewing prospects. The next total solar eclipse will occur in 2019 and will be visible in Chile and Argentina. The next eclipse visible from the continental U.S. won't happen until 2024, but weather odds are not as favorable as for the event this August, according to Anderson. The great advantage of this eclipse is you can just get in your car and drive to it, he says. All right, now let's get back to our jury charge. Ready? Here we go. This is not to say that we are not aware of the unfortunate congestion of the court calendar in many of our district courts. The use of procedural devices in the heavily congested districts has proved to be most helpful in reducing docket congestion. Illustrative of such techniques are provision for an assignment commissioner to handle the assignment of all cases, the assignment of judges to handle only motions, pleas, and pretrial proceedings, and separate calendars for civil and criminal trials in cases that have reached issue. We enumerate these merely as an example of the progress made in judicial administration through the use of enlightened procedural techniques. It goes without saying that they can be used effectively only where adaptable to the specific problems of a district. Congestion in itself is not such an exceptional circumstance as to warrant a reference to a master. If such were the test, present congestion would make references the rule rather than the exception. Petitioner realizes this, for in addition to calendar congestion, he alleges that the cases referred had unusual complexity of both issues of fact and law. Most litigation in the antitrust field is complex. It does not follow that antitrust litigants are not entitled to a trial before the court. On the contrary, we believe that this is an impelling reason for trial before a regular, experienced trial judge, rather than before a temporary substitute appointed on an ad hoc basis and ordinarily not experienced in judicial work. We believe that supervisory control of the district courts by the courts of appeal is necessary to proper judicial administration in the federal system. The All Writs Act confers on the courts of appeals the discretionary powers to issue writs of mandamus in the exceptional circumstances existing here. Its judgment is therefore affirmed. All right, let's get back to some literary material. And an article that we had started on captioning. Called Captioning Conventions, A First Experience. So we'll finish this up, it looks like. Ready? Here we go. Now that you've gotten your feet wet captioning a convention, do you have any thoughts of going into broadcast captioning? Oh, let me think. No, actually, since the convention I have been thinking I might like to try my hand at doing some broadcast captioning. Again, it seems like quite a challenge to do live TV, especially because some of the sportscasters and news reporters speak so quickly, along with the quick interview style exchanges between people. Another hurdle to overcome? Do you have any words of wisdom for those that see captioning as easier than legal reporting? Easier is not a word I would use in conjunction with captioning. Granted, from the outside looking in, it would appear that captioning is easier because you have no transcripts to produce, but there is preparation time each day that is an essential element to captioning to do a good job. There are several components to captioning that are necessary to performing the job optimally, including being a clean writer. In the legal arena, if you're having a bad day, most often no one is the wiser. You are able to go home and clean up your transcript, especially with the use of audio sync these days. With captioning, if you're having a bad day, everyone is the wiser. I think about captioning the way I feel about real-time reporting. And as I have to tell my attorney clients who think anybody can do real-time reporting, sure, every reporter is able to do real-time from a technological standpoint, but not every reporter can write real-time. In my opinion, to be a captioner from a writing standpoint, one must be a clean and conflict-free writer as a foundation to even start thinking of captioning. You can't fake the writing without anyone knowing, but I feel the second priority for captioning is to have a mentor. Ask questions of experienced captioners who are enthusiastic about what they do and how it's done. Obviously, my foray into captioning was less stressful than most because I simply knew I would be working side by side with a very experienced captioning expert. Being able to ask questions, get the right answers, and actually learn from someone exactly what to do and what not to do was invaluable. Even though I don't know the ins and outs of all the aspects of the captioning world, yet I came away from the experience with my eyes wide opened, feeling like a new door had been unlocked. What was your most embarrassing moment during the week? Any bloopers you want to share? Okay, I'm talking writing issues now. I'd have to think about that one without going through my files. The one that comes to mind was the cheer that was periodically yelled out during the convention, hip hip hooray. It came out as hoop hoop hooray. That evoked a snicker here and there. Maybe you remember seeing one while I was writing, and you have my permission to share. I think I was so intensely focused on what I was doing, I tried not to get distracted by looking for bloopers. All right. Back to some jury charge. And this jury charge looks like it's about some type of an accident. Ready? Here we go. With respect to defendant's replies to these arguments, it is sufficient to state that it is contended that plaintiff's version of the accident was incredible. The only charge of negligence in the complaint was the failure of defendant to maintain a barrier around the pit, and plaintiff's claim that he stumbled over a steel rod was an afterthought. If plaintiff were walking parallel to the pit, he would not have stumbled into it, and if he did, he would not have landed on his feet. Defendant's witness, Henry Corbin, an employee of the Smith Trailer Company and lead man on plaintiff's shift, testified that plaintiff received his injuries while he and fellow employees, Ralston and Thompson, were jumping in the pit from the shallow end into sand toward the deeper end. There was no evidence from which it could be inferred that defendant was responsible for placing the rod on the ground or that he had actual or constructive knowledge of its presence. Plaintiff could not plead one specific act of negligence and recover on proof of another. It was alleged in the complaint that plaintiff was lawfully on the premises, meaning presumably that he was not a trespasser. He says he has always supposed that he was an invitee of Rose, but he has mentioned no fact that would indicate the existence of that relationship. Defendant is accused of only passive negligence, consisting of the alleged failure to maintain the portion of the premises he was using in a reasonably safe condition. Whatever duty he had with relation to the condition of the premises arose out of the relationship between himself and the plaintiff. The only theory of the case plaintiff advanced in his briefs was that he was a business invitee. He cited Davis versus Hager Food Stores, which he said is a case exactly in point. In that case, the defendant operating a food market was held to a high quantum of care to keep his premises in a safe condition for his customers and chargeable with knowledge of an unsafe condition. For reasons to be stated, we are of the opinion that plaintiff's status was that of a licensee or a trespasser. Defendant was an occupier of that portion of the premises, use of which was necessary for or incidental to the work he was doing for Smith. Plaintiff, as an employee of Smith, was its invitee, but this did not make him an invitee of defendant with respect to the area in and immediately surrounding the pit which defendant was using. They had no business together. Plaintiff's presence in the vicinity of the pit was of no concern to defendant. The washroom was not maintained by defendant and was not under his control. It was not shown that it was necessary for plaintiff, in order to reach the washroom, to walk close to the pit. There was no evidence that he had followed that course before, and no evidence that defendant had ever seen him in the vicinity of the pit. On the day of his alleged injury, plaintiff was on a mission of his own. There was no basis in the evidence for an inference that his presence in this area at any time was invited by Rose. It could be argued with considerable force that plaintiff was not even a licensee, in that it was not shown that he had either expressed or implied permission to walk around the edges of the pit. in view of the nature of the work that he had been doing and would continue until the pit was completed, it would be a reasonable assumption that Rose would have preferred that strangers to the work would remain away from the pit and the area around it, which he was using for deposit of the excavated material. However, inasmuch as plaintiff was not a business invitee, it is immaterial whether the facts would have justified a conclusion that he was a licensee of Rose and not merely a trespasser. In general, the possessor of land is not liable to harm to trespassers caused by his failure to put the land in a reasonably safe condition for their reception, or to carry on his activities so as not to endanger them. If the presence of the trespasser is discovered, the possessor is commonly required to exercise reasonable care for his safety as to any active operations the possessor may carry on, and possibly as to any highly dangerous conditions on the land. A licensee is a person who is privileged to enter upon the land by virtue of the possessor's consent. The possessor is under no obligation to exercise care to make the premises safe for a licensee's reception, and is under no duty toward him except to use reasonable care to discover him and avoid injury to him in carrying on activities upon the land. Furthermore, the licensee has no right to demand that the occupier change his method of conducting activities for his safety, and in the usual case, if he is fully informed as to what is going on, or it is obvious to him, he has all that he is entitled to expect, and he assumes the risk thereafter. If we assume, without so deciding, that plaintiff was a licensee complaining of an unsafe condition of the premises, the applicable rule is the one stated in Jenkins versus the Columbia Petroleum Company, namely, where a person goes upon the premises of another without invitation and simply as a bare licensee, and the owner of the property passively acquiesces in his coming. If an injury is sustained by reason of a mere defect in the premises, the owner is not liable for negligence, because such a person has taken all the risk upon himself. And that will conclude our literary and jury charge practice.